Michael Bekesha is on with us, Judicial Watch senior attorney. Hello, Michael. How are you?
I'm good. Thanks for having me.
Good. So let's talk about Trump's case. Alan Dershowitz is coming on in a minute, and he's saying that he thinks he's in trouble on this one. You're saying the opposite. So explain the case that they have against Donald Trump and where you think the bright spots are.
Yeah, so basically the prosecution of Donald Trump with respect to the documents all started because the National Archives, somebody at the National Archives thought that maybe President Trump had some records that maybe he shouldn't have taken with him when he left office. That's how this started. And in the Wall Street Journal, I wrote a piece talking about a similar case that Judicial Watch had against the archives when it came to President Clinton and his records. While he was in office, President Clinton created these audio recordings. And on these audio recordings had all sorts of information. You know, they had conversations with foreign leaders. It had discussions about cruise missile attacks to get Osama bin Laden. It had information that would be classified had it gone through proper channels. But instead, President Clinton kept these tapes in his sock drawer and decided to take them with him when he left office.
And did he declassify them before he took them?
He didn't do anything.
Okay.
According to what we know, he simply took them with him. And Judicial Watch wanted the tapes when we found out about them. We figured, you know, these are presidential records. These are tapes showing President Clinton being president. So we sued the National Archives for the tapes. And in that case, between 2010 and 2012, the Justice Department, the Obama Justice Department, took the position that whatever President Clinton took with him were not presidential records, they were personal records, and there's nothing that they could do to get them back. In 2012, the district court here in D.C. agreed with the government and the judge in that case, and she said it is the sole responsibility of the president to decide what records are personal, what records are presidential, and once they are taken out of the White House, there's nothing that the court could do to get them back.
Now, is that because, I'm just trying to play devil's advocate, is that because these were tapes that he made and not top secret documents? Even though they may have contained top secret information, but he made the tapes.
You know, Glenn, it doesn't really make a difference because it wasn't as though President Clinton was, you know, pressing record and going out and buying the tapes. You know, based on, he was doing this along with a historian, and based on the historian's discussions about it, what he's told the public, the White House operations staff helped schedule the interviews, helped prepare the tapes, probably went out and purchased the tapes. And so the only thing that President Clinton did was place the tapes at the end of the session into his sock drawer. And that's very similar to what President documents.
Right.
If you look at the indictment, paragraph 2 says, while he was president, Trump placed documents in boxes. Paragraph 4 says, when President Trump left office, he took those boxes with him. To me, it's not a sock drawer, but it was boxes. It was the same process. President Trump decided what he wanted to keep, what he wanted to leave, and he took what he wanted to keep with him when he left office.
Okay, so help me out on this. Again, I want to ask you tough questions because I really don't know legally where this is headed, and except all the way around trouble. Trump's defense is that his actions were protected under the Presidential Records Act, but that act excludes, and I'm quoting, any documentary materials that are official records of an agency. So the indictment alleges that he had the information about our nuclear program, defense, weapons capabilities, potential vulnerabilities of the U.S. and our allies. Is it is it your view that these kinds of documents are protected under the PRA because of the Bill Clinton, or is there more?
There's more. The fact that the Presidential Records Act talks about agency records is really a red herring, because as the courts, the D.C. appellate court here found that really the focus is, are the records received by the president? Once the president receives a record from the agency, it's no longer just an agency record. It's now a record received by the president. So it has a different status. I mean, just imagine, it doesn't make sense that once the president gets a record from the agency, is it like a library book and he has to return it within 21 days? Absolutely not. It's his record, and under the law, he can do what he wants with it.
Right, and there are exceptions. No. It is treated that way with things like the nuclear code. He has access to that, but it's in a football held by a member of the Department of Defense that's with him all the time. So there are some records that do have to be signed in and signed out, right?
Well, maybe. I mean, the question is, what is allowed by the Constitution? And these are questions that really have never been addressed. The President of the United States is commander-in-chief. Everything in the executive branch flows from him. So there is one question on, what limitations can Congress place on the commander-in-chief, but also there's a question of whether or not Congress can mandate and require another branch of government to do something. And so there are strong arguments that if the Presidential Records Act is what some folks say it is, then that would be unconstitutional because it's placing burdens on the office of the president that's not allowed. The other question under the Espionage Act is authorization. While someone is in office, while President Trump was in office, he was authorized to maintain that information, to maintain those documents. If you went into the Oval Office, he could show you that document because he had absolute authorization to do what he wanted with it. So the question is, did he authorize himself to take those records with him when he left?
But hang on just a second, because he does have the ability to declassify, but even according to his own words in the indictment, there's a transcript of a conversation where he holds up a classified document to somebody and he says, somebody writing a book about him, see, as president, I could have declassified this. Well, now I can't, but so this is still a secret. So he knew that he possessed something secret. He knew that he hadn't chosen to declassify it as president. And now he's showing it to a member of the press, not as president.
Right. And the question there, and I think it's facts that, again, indictments are just one side of every fact. And
Okay.
I don't know the facts. You don't know the facts. The American public don't know the facts. But the question is, whatever document he had in his hand, how did he get into his hand? And I think what we need to do, and what the public needs to wait, is to wait until all the facts come out to see whether or not he was in fact authorized to still have that record. And maybe the facts will show that he wasn't. I keep thinking, if President Trump, after he had left office, somehow got access to records he didn't have access to when he was president, that would be
A problem.
where a problem may lie.
Right.
But if the records were in his possession while he was office and he took affirmative steps to maintain those records when he left, there are real constitutional legal questions about whether or not that was authorized.
Okay, let me give you a statement from Bill Barr. And I'm sorry, I'm just playing devil's advocate because I want to hit both sides. I'm going to hit Alan with the same thing. Both sides hard because I want to ask the questions that people are not asking, but I think the American people are asking. There's a statement from one of not my favorite people in the world, former Attorney General Bill Barr. I want to give you a chance to respond to it. He said, quote, I think the counts under the Espionage Act, that he willfully retained those documents, are solid counts. They gave him every opportunity to return those documents. They acted with restraint. They acted very deferential to him, and they were very patient. They talked to him for almost a year to try to get those documents, and he jerked them around. They finally went to a subpoena, and what did he do? According to the government, he lied and obstructed that subpoena. And when they did a search, they found a lot more documents. They're official records. They're not his personal records. Battle plans for an attack on another country. Defense Department documents about our capabilities. In no universe, Donald J. Trump's do these belong, or are personal documents of Donald J. Trump?
There's a lot there. To begin with the end part, the Obama Justice Department would disagree. So with the federal court that concluded that once a president leaves office, it is assumed that the president chose to take those records, had designated them as personal, and that there was nothing that could be done about it. And so just because former Attorney General Barr doesn't think those records should have been taken doesn't mean that lawfully they couldn't have been taken. The other interesting part is Attorney General Barr seems to focus a lot on the fact that President Trump may have not for all the records that he had been asked to turn over. Well, under the Espionage Act, that's irrelevant. So even if he had returned those records, if the espionage is what everybody thinks it is, then President Trump could have still been charged under the Espionage Act.
Okay.
And so this idea that it's somehow different because he still had the records really is just showing an emphasis that he's displeased or unhappy with President Trump's actions and has nothing to do with what the law actually is.
When Trump was indicted last week, I was on vacation and I was not paying attention to the news. And I mentioned it on Monday when I came back, but I told you I wanted to really get the best minds on both sides and talk to them. And because there's people who have defended Trump and may like Trump, but one of those who I think is very credible on this, because he has defended Trump time and time and time and time again, written books about it, now says this is real trouble. And his name is Alan Dershowitz. So I just had, this is no big deal, we can win this. And he says there's real trouble. So let's get the real trouble side now from Alan Dershowitz. Hi, Alan. How are you?
Hey, how are you? There's real trouble, but that doesn't mean that it can't be won. This is a very, very serious charge. You know, in my book, Get Trump, I predicted all of this. I also predicted the indictment of Hunter Biden on minimal charges in order to demonstrate the claim that there's equal justice. But the problem with Donald Trump is illustrated by that plaque that some people have in their homes with a stuffed fish on it that says, if I had only kept my mouth shut, I'd still be swimming. All of Trump's problems come from his own statements. What he said, the most serious one, is what he said to a writer who was writing a book on Meadows, in which he allegedly showed him some classified material. He says it wasn't. He said it's just newspapers. You hear on the tape apparently rustling, and I don't know what the facts are. And saying, I could have declassified this, but I didn't, so it's still secret. That seems like the government will use it as an admission that he didn't declassify everything. If he hadn't said that, his claim of declassification would be very strong. Then he spoke to his lawyers. Now, I don't think those statements should ever be admissible. Those are lawyer-client privilege statements.
Thank
if
you.
I were his lawyer, I would be fighting like hell to keep those out because I can't talk to my clients anymore as a result of that ruling.
So wait. I watched enough Perry Mason, and I know that's not actual law, but if you break the bond of attorney-client privilege, sometimes you're working with a dummy like me, and I'm like, I don't know, what happens if we don't give him to them? Well, I'm asking for your legal opinion.
What if you tell it to a priest? What if you say to a priest, I know this would be a sin, but I'm thinking perhaps maybe of not giving it over. And the priest says, no, you must give it over. Or you talk to your doctor. all these privileges are now at risk as a result of this terrible decision made by judges who were handpicked by the special prosecutor. Remember, the case is in Florida, but this special prosecutor brought these legal motions to compel the lawyers to speak in D.C., where he knew he'd get a more favorable court. So he was judge shopping, and then he got his favorable rulings, and then he takes the case to Florida.
Wow.
And I would hope the Florida court would look at that in a very, very critical light, because, as I say, I have to tell my clients now, don't ask me any questions, because I may have to disclose them. I'm not taking notes anymore with clients. I'm not turning over anything that my clients tell me in confidence just because some court says, and then there's this absurd thing of a taint team where if you say something's lawyer-client privilege, the government says, all right, we'll pick some government lawyers who have lunch every day with the prosecutors and who stand next to them in the urinal every day, and we will allow them to look at the lawyer-client privilege material, read them, and, they promise they won't, with a wink and a nod, say anything to the prosecution. That's what's happening now. And Judge Cannon had the courage to write a decision saying, no, she was going to appoint an independent judge, a former judge, a great judge in New York, to look over the lawyer-client classified materials. And the court said, no, that's special treatment for Trump. No, that's what everybody should get.
So the crime fraud exception to attorney-client privilege, you don't buy into that here?
I buy into it in general, but I have to tell you, I've done 250 cases involving criminal defendants. I would say in half of them, the conversation included some reference to maybe if I went to Brazil, I couldn't get caught. No, you can't do that. You'll get caught. But, the client raises all kinds of questions. That's why it's confidential.
Correct. It's the same as the
anything they want.
Isn't it the same reason why we have the presidential confidentiality when you're talking to the president in the Oval and you're brainstorming? People don't want to say things that maybe are unpopular, or will say things that are maybe crazy in hindsight, but you're brainstorming. I don't want that on the record. I want to be able to have a private conversation. If you can't have that, you don't really have anything.
No, I agree with you. Look, when I taught at Harvard for 50 years, I would say to my students, what you say in this class is confidential, and you can be as speculative as you want. You can say any wild thing about criminal law. You can make statements that you would be ashamed to have made public. This is for a Socratic discussion, and in Socratic discussions, anything goes.
The indictment doesn't ever mention the Presidential Records Act.
Or the word espionage. Or the word espionage. That's being thrown around all over the place. Yeah. So
where is, because I have gathered from what I've read from you that this serious charge, and he's going to have a hard time. Why? It sounds like there's a lot of other legal issues to really go after.
There are, and that's why it's not a slam dunk case. That's why the case should never have been brought. I said that you don't bring a case against the man, forget about former president, you don't bring a case against the man who's running to become the president against the incumbent head of your party unless you have a slam dunk case. Now, I think they have a case, but it's not a slam dunk case. There are these legal issues involving lawyer-client privilege. The government doesn't have the piece of paper that was waved allegedly in front of this writer, so they have a hard time proving that. They have to deal with the classification issue. It's a winnable case, but it's also a losable case, whereas the case in New York is absurd. The case in New York, the prosecutor should be disciplined for bringing it. In 60 years of doing this business, I've never seen a weaker indictment than New York. I cannot say that about the Florida case. That doesn't mean it's going to end up with Trump being convicted, particularly since the trial is in a fair district, unlike Manhattan.
Okay.
I love Manhattan. I live in Manhattan, but you can't get a fair trial for Donald Trump in Manhattan. Maybe you can in Palm Beach County.
Okay, so let me take you through the crazy scenario that he goes to trial in the middle of an election season. Right. He's convicted, sentenced. What does this look like? We didn't do this with Nixon. We've never done this before. What does this look like?
We hope we'll never do it again. Nobody knows what it looks like. The only thing we know for sure is he can run for president, even if he's in prison. Eugene V. Debs ran for president when he was in prison. Curley became mayor of Boston while he was in prison. The Constitution specifies only several criteria, and the Constitution means what it says. So you can run. You can even serve as president while in prison. That's not going to happen. Judge is not going to sentence him to prison. So these crimes did not endanger national security. They are not espionage. The media is throwing around the term espionage. The first thing that has to happen is this trial must be on television. We, the American people, do not trust the media to tell us the truth about the trial. Mm-hmm. If you watch MSNBC and CNN and read the New York Times, you're going to think it's an open and shut case of guilt. And if you see other networks, you're going to see it's an open and shut case of innocence. You know, I was a lawyer in the O.J. Simpson case. There was a poll that showed that people who actually watched the trial on television were not surprised at the verdict. But people who read about it in the newspapers were shocked beyond belief. So we have to be able to see this trial. And the word espionage should not be allowed to be used in the trial by the prosecutor. And if he does use it, there should be a mistrial with prejudice.
Why is espionage? Where did they even get that?
It's the name of the statute. It's as if Congress passed a statute entitled the Child Molestation and Insider Trading Act. And they indict somebody for insider trading, and they go in front of the jury and say, this man has been indicted under the Child Molestation and Insider Trading Act.
Wow.
It's the name of the statute. It was passed in 1917 to go after war resistors, mostly religious people who had a conscientious objection about going to the First World War. And Woodrow Wilson passed the Espionage Act, which had very little to do with espionage. It had mostly to do with dissent and whistleblowing. And all of the whistleblowers have been indicted under the Espionage Act. I've defended many anti-war protesters and other dissenters under the Espionage Act. And the government loves to use the word espionage. But there's no allegation here that
Alan
anything went to foreign enemies.